I'm actually going to try to make this as entertaining as I've ever been able to pull off with an intellectual property discussion. There are some things in here that are really critical to life or death for innovations, anything in the entrepreneuring space, but innovations in general. So intellectual property, we'll just start with, people talk about IP, they talk about intellectual property. Not all the time is everybody clear on what that means. So intellectual property is a noun. It's a work or invention that results, the result of creativity. It could be a manuscript, a design, and one has rights to it. So intellectual property is something you can own. And we'll talk about what that ownership is good for. It is an intangible property, right? So it's not like real estate, which is real property. This is intangible. And you can control the rights to own or use intellectual property. So there are 4 general types of intellectual property. There's trade secrets, patents, copyrights, and trademark. All of them start as trade secret. Right? So it's something you know that other people don't know. That's the intellectual part of the intellectual property. And in some cases, they just stay that way. They never go anywhere beyond that. And there's actually reasons to keep things as a trade secret as opposed to patenting them. As a secret, you can sell the secret. The secret can be stolen. You can lose the secret. These are all things that can happen to it. The classic example for trade secret that is, I think, most commonly used would be the formula for Coca-Cola, which has never been released. I don't know whether it's ever been stolen and whether they had to bring in detectives to, or maybe a hit squad or something. I don't really know, but you could imagine that this formula is in a safe somewhere and someone could steal it. One of the reasons why you might stick with a trade secret rather than a patent is because in order to get a patent on something, you actually have to tell the world what it is. Right? A patent is a very strong protection, but a patent is a time-limited thing. And the formula for Coca-Cola would long ago been in the real world if it had been patented. We're going to talk mostly tonight about patents. So a patent is a government-issued right of ownership. And to get a patent, you must meet the criteria of an invention, which we'll talk about. And your rights are time-limited, and we'll talk about what the timeline for patents look like. Copyright is more commonly used than it used to be for protecting things in the digital space. So typically when people think about copyright, they think about music or literature, but it turns out that patenting software is almost impossible now. And so a lot of the protection around software is in the copyright space because after all, software is something you write. And then trademark is a commercial trade protection. You acquire it. In order to get a trademark, you actually have to use it. So you can't say, I want a trademark on something that I have never sold or have not even made yet. You can't get trademarks on things like that. And you don't even need to register it in order to have trademark. You have trademark if you use it. Okay. So why does one own intellectual property? So property of any type, why does anybody own property, right? Why do I own this jacket? Because I like to use it. Why do I own a piece of art? Maybe because I like to gaze upon it and enjoy it. In the case of intellectual property, we are owning intellectual property because it's a barrier to entry. That's the primary function of intellectual property, is to keep people out of whatever it is you're doing. This is my idea. You can't have it. You can't use it. That's what my intellectual property function is. So it's a way of blocking others from a commercial opportunity, right? You put up a fence, you put up a wall around what it is that you're trying to accomplish. So, as I said, we're mostly going to be talking about patents tonight. Excuse me. Patents are the most common type of intellectual property barrier to entry that we're going to be looking at in the life sciences. So whether it's a device or a drug or diagnostic, a tool, the place where, again, patents you'll see less of is in the digital space. Copywriting is more common there. A patent is a legally enforceable monopoly. It's generally the way it's described, although there are some who don't like that description, but that's generally reasonable enough. And that monopoly is, under the way patents work now, for most things, generally, none of this stuff is precise, exact, all the time, about 20 years. Right? It's 20 years from when you do a utility application. We'll talk about what that is. And patents are obtained by application of the government, and you must meet the statutory criteria. And there's slightly different criteria in most countries. The United States and Europe are the two most, I think, common discussed intellectual property and patent regulations and rules and statutory criteria for products being developed here in the United States. But even inside the European Union and with many other countries, there's some differences. We'll go over things which are going to be common amongst them. The U.S., so what sort of things can be patented? U.S. statute says there's 4 types of patented utility inventions. There are other kinds of patents which we're not even going to talk about. Of the patentable inventions we're talking about here, you have machines. And a machine is basically anything you assemble together that does things, right? So I gave you an example of active flow cytometers. That could be a machine, right? Articles of manufacture, so anything that you took raw materials and converted them into something, and it wasn't a machine, would be something there. Processes or methods, and we'll talk a bit about methods here. So a method of treating a headache by administering ibuprofen, and compositions of matter. And in the drug space, this is really the king. What you patent the formula, the chemical formula for a new chemical entity, one that you've engineered and has not existed or people didn't know about before. That's the strongest protection in the drug space. So what kind of things can't be patented? You can't patent mathematical formulas. You can't patent most algorithms that are involved in software. You can't patent naturally occurring materials, and that includes nucleic acid, proteins, other things. So a naturally occurring, for instance, a naturally occurring DNA segment, this is the Supreme Court talking here, is a product of nature and not patent eligible merely because it has been isolated. So you can't just purify it and say, well, I cloned it and here it is, so I protect it. Unless, of course, you sufficiently modify it so now that it's different. So if you were to make PCR primers against a sequence in there, the primers themselves may be patentable and protectable. So we're going to talk about half of the presentation we're going through tonight. We're going to cover the concept of patentability, right? Which is a word that means can you make a patent out of it? What is it? Something that can be patented. There are 3 canonical elements of patentability. In the United States, they're known as novelty, non-obviousness, and usefulness. In Europe, non-obvious is replaced by, they use a different terminology, but the concept is almost the same. And you need to have all 3 of these things, every one of those things, not short of any of them, in order to be a patentable invention. And I'm going to walk through what those things mean. I need to give you this background before we can get to the more interesting parts of this presentation. So, novel means not seen in public before. That's it. There are more things on this slide, but just remember that, okay? So not seen in public before. Another word or term that we're going to use a lot is prior art. So not seen in public before. Anything that has been seen in public before is considered to be prior art. So it's prior, meaning it came before. Art just means it was something that was documented in some fashion. Anything can serve as prior art, so writing, images, and verbal descriptions. Any description of the invention by anyone, either the inventor or not the inventor, destroys novelty. So if someone in the last paragraph of a journal article, a technical article says, oh, and maybe someday somebody could figure out how to do this. They have just described something that you might want to patent in the future, and you would have to fight with the patent office to make the argument that novelty hasn't been broken, even though they didn't actually do it, and they may have just done it as a toss-off at the end of an article because it seemed like a good thing to put in a discussion section. That becomes a challenge for novelty. There are ways around it, but it's a challenge. In the United States, there's a grace period on this destruction of novelty. So if you're the inventor, in the United States, you have up to 12 months to file for a patent application on something which you have disclosed. This is not the case in Europe. In Europe, if you're standing in front of an audience like this and you say, I have this great idea for this invention and here's how it would work, it can never be patented in Europe. It's over. At that instant, it's over. In the United States, somebody could say, hey, that was a great idea for a patent. Did you file a patent on it? You'd be like, oh, crap, no. And you'd run to the tech transfer office and they could file an application for you and you could get coverage in the United States, but you could not get coverage in Europe. Okay. We'll go over some timelines a little bit later. So then we have non-obvious, which is known as the inventive step. That's what they call that in Europe. Concept is, as I said, about the same. So if you have an idea that nobody else has ever had, it has to also be an idea that nobody else would be expected to have. That is to say, it isn't just obvious. It may be the case that no one has ever thought of, for instance, this is a judgment by the examiner, but the example I've given here is a rubber tire. So if we knew a lot about rubber and we knew a lot about tires and we were using tires and we were figuring out all different kinds of ways to make tires kind of grippy and absorb, and somebody says, well, we could use rubber, and everybody would say, well, of course we could use rubber. We just never used rubber because we've been using something else. If you were to go try to get a patent on that, they might say, well, that's kind of obvious. Everybody knew you could use rubber on a tire. We just hadn't bothered to use rubber on a tire. So the fact that it's novel and it hasn't been done before doesn't mean that someone who's skilled in the art would not have been able to predict it or anticipate it. And again, this is a judgment call. There are a lot of things, patent applications, which are denied based on obviousness, and a lot of arguing goes back and forth with the examiners about what was obvious and what isn't. Sometimes you have to find, it's actually really helpful if you can find the textbook on tires, and the textbook says, and rubber won't work. That's a really good one. You photocopy that, you send that into the patent office, and you say to the examiner, you see, it's not obvious. I've actually done that. Not about rubber tires, about something else. Okay. So then the last item is it must be useful. Now, in this case, we generally don't have too much trouble with usefulness in the life sciences. In the United States, the usefulness is you can describe a specific, credible, substantial utility for it. In Europe, it's an industrial application is how they call that. The challenge that you would have is if you were, for instance, the idea of patenting a piece of DNA, a sequence of DNA, you can't just say, well, I found this sequence and so I want to patent it. You'd have to describe what utility you would have with it, what usefulness it would have. In most cases, if we're talking about a drug or a medical device or a research tool or a laser pointer, going over the concept of why that is useful is not very difficult. Right? In most cases, you don't have to argue it very much. It becomes self-evident. Okay. So one thing that's not useful is something that can't exist. Perpetual motion machines are the example given most commonly when this topic is discussed. Since a perpetual motion machine can't exist, it can't be useful and you can't patent it, despite the fact that the Patent Office has attempted to give out patents on it. That is the example that we're all taught. All right. So then there's concepts that are not part of the big three of patentability, but are very important, and patents get rejected, patent applications get rejected on them. This is written description and enablement. So as a metaphor for this, I'm going to use a cake, right? Cake recipe. So if you think about a patent as a cake recipe, we're going to describe there's going to be a cake, it's going to be very beautiful, it's going to be very flavorful, it's going to be wonderful, 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 and here's the description of how to make the cake. That's the recipe. Okay? So we're going to have a patent and it'll have a recipe in it. The written description requirement says that the recipe has to be fully functional and it has to be fully disclosed. You have to write it down. Written description, write it down. And the reason this is important is because you can't just say, well, I think it would be great if we could go to Mars. You can't have a patent on something that will take you to Mars because you haven't figured out how to go to Mars. You actually have to describe how you're going to do it. So, for instance, if we take eggs, flour, and baking powder, and we heat them up, we do not create a cake. That is not the same as producing a cake. And so you have to actually write down a description of what that recipe is going to be. Now, an interesting aspect of this is if the recipe is correct, technically you don't even need to have ever made the cake with that recipe in order for it to be something that could be patented. One can be clairvoyant and say, well, I know enough about cake recipes and I know that if I make this change, which no one has ever anticipated and has never been discussed before, it would produce a very flavorful cake and I'm going to patent it. And then someone bakes that cake and says, yep, it's very flavorful. Then you would have a patent that would stand up. The issue here is enablement. So you have to have a recipe that actually works. The best way to know that a recipe works is to use it, make a cake, document that it's flavorful, and show that to the patent office. Then they're pretty sure that your recipe works. In some cases, again, for a perpetual motion machine, if you provide evidence that your perpetual motion machine actually is in perpetual motion, you could get a patent on it. But that's the problem. You'd have to show the evidence. If we were able to do it without showing the evidence, we would have what we'd call a prophetic patent. Right? I am sure this recipe is going to work. You can file a prophetic patent. You may not be able to get a prophetic patent. In other words, you may not actually get the patent office to give you a patent to approve your application until you prove to them the recipe works. But that might be years after you've written down what the recipe is and protected it, and then claim the protection back to when you filed the application. So you may bake the cake later, but protect the recipe today. The challenge with that is the cake that you bake has to be based on the recipe you applied for. And if you changed the recipe, you didn't get protection back to when you claimed that you had protection. So the way this is talked about, so someone has to be able to look at your recipe and be able to figure out how to make a cake out of that. In the life sciences, patents usually require working examples to prove the enablement. And This is a judgment call on whether or not you should try and protect something before you've actually shown it's worked. You usually want to get some preliminary data because you can't be sure whether or not you have figured out the recipe until you at least have done a test cake, right? Yeah?
What about computer modeling? Is that valid?
Yeah, so yeah, probably not in the end. If the examiner doesn't believe that you can pull it off, they may not buy that you can do it by modeling. Usually, any kind of working example, as coarse as it can be, that still proves a proof of concept, is effective. Computer modeling might be really useful for you as an inventor to be convinced that your recipe is going to work and that you should file for protection on that recipe because you're not going to be changing that recipe substantially between now and the time when you actually get it to work because your modeling has shown that it's going to work. This is the challenge. If you say, well, I'm pretty sure I know the recipe and I file the patent, I go to file for the patent, and then it turns out as I'm baking it, I was like, yeah, it really needed a pinch of salt and I didn't put that in the recipe. The examiner may say, well, you hadn't fully enabled it, right? You didn't have a complete written description. Your recipe was incomplete. I can't give you protection for this recipe because you hadn't completed it yet. One item that I get asked a lot about, and I thought I'd just stick it in here, is if we're doing all the inventing, who's an inventor? So inventors have to be able to have come up with a thing that you can put in writing that is enabled. Right? So that's a way of thinking about it. Inventors must have a substantial contribution to the conception of the claims. We'll talk about what the claims are. But the innovation, they have to have been part of the conception of it. The conception is the process of defining an idea sufficiently that someone of ordinary skill, now there may be ordinary skill in the particular field, so maybe somebody who's highly technically trained to be able to work in a chemistry lab, that sort of thing, but anyone of ordinary skill could pick up your recipe and make a cake. So a reasonably skilled cook would be able to make a cake based off of the recipe that you have. If it takes more research or testing or modification in order to make it work, then you haven't done the enablement and you haven't created the invention and you're not an inventor. However, if you conceive of the recipe and you hand it to someone and you say, go make a cake out of this, I'm pretty sure it's going to be a cake, and they make a cake and it's a good tasty cake, the person who made the cake is not an inventor unless they were part of the conception of the recipe. Okay? So reduction to practice is what that's called. So here's a recipe, never tried, try it. That's reducing it to practice, is what that's called. That's not sufficient for inventorship. Inventorship is more restrictive than authorship. So it's very common in the technical space that everyone who's involved in the project, the person who conceives of the problem that we're trying to address and designs the experimentation, and the person who conducts the experimentation, they may all be authors on a paper. It doesn't work that way in patenting. So a little bit about how to read a patent. I'm going to cover about 1/100th of the amount of information I could on this particular topic. A patent has 3 basic parts that we're going to talk about. So there's a front page. This is probably not a surprise to you. This would be in the obviousness category. If you have a patent, it has a front page. What's interesting about the front page is you'll find critical pieces of information there. The title, which is generally not critical. The dates, the inventors, and the assignee. The assignee is who owns the patent. It may be the inventors, or if you're an employee of the University of Michigan and you do an invention, the University of Michigan owns the patent. So you may be the inventor, but the University of Michigan is listed as the assignee. So the front page is going to have these sort of facts in it. Then we're going to have a portion of the bulk of the patent is called the specification. this would be your description of your yummy, tasty cake, right? So if we were writing a menu about your cake, the things in the menu, like this is a delicious cake made with chocolate and it melts on them, all that stuff, that would all be in the specification. So there's going to be a summary of what the invention is, going to be drawings of your delicious cake, there's going to be a description of the cake, and there's going to be a section called embodiments, and these are generally examples of how you would make a cake with your recipe. You could make a cake on Tuesday, you could make a cake with brown sugar, you could make a cake with a friend. There'd be examples of how you could be making a cake. The most important part of the patent is the last item here, and that's the claims. And the claims is the recipe. We're going to make a cake. We're going to take so many eggs and so much flour and so much baking powder, so much sugar, and we're going to mix it together in such and such a way, and then we're going to bake it for so long at this temperature. That's the recipe. Those are the claims. And the reason they're called claims is because they claim something. This is mine, right? So you can think of a mining claim, right? This is, I'm digging here. Nobody else is allowed to look for gold in this spot. I claim it. The claim in the patent also says nobody else can perform this recipe. It's mine. You can't have it unless you ask nicely. Okay. So an example of claims. A cake comprising of flour, egg, butter, sugar, and baking powder. Right? So this would be what we would call an independent claim. I'll show you a dependent claim here. So a dependent claim would be a cake of claim 1, right? So a cake blah, 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 you just don't repeat all of that. You just say claim 1. And the flour is white, right? So you're claiming a cake and a white flour cake. And you're stuffing some other things in there. The eggs are free-range eggs, right? So you're doing more of a description. It's important to understand the difference between an independent claim and a dependent claim when I give you some marching instructions about how to go look for things in the patent world, should you need to. The things that you're going to be most interested in are the independent claims. Generally, if you don't have a problem with someone's independent claims, you're not going to have a problem with their dependent claims. Another example of an independent claim would be this one. A method of making a cake comprised of mixing these things together and baking them in an oven for 350 degrees. This is an example of a composition and matter claim, and this is, you could probably guess, a method claim. These are the two most common types of claims you're going to be running into in this space trying to patent things. You may have a patent which has 20 claims. Those 20 claims may only be 1 or 2 or 3 independent claims. That's very common. In fact, the Patent Office likes to restrict how many claims and how many independent claims you can have on things now. If you were looking at somebody's patent and you were concerned about whether that patent was going to affect you, the first thing that I would do is I'd be screening through to find everything that didn't start of claim, right? Anything that starts like this is a dependent claim. I would just not even bother to read that. I would be looking for the things that didn't start that way. Those are the independent claims. That's the stuff we need to worry about. And I will tell you next about why we need to worry about it. So here's another dependent claim, right? So you can say, well, we're baking it for 30 minutes or 60 minutes, right? Okay, so we're getting to the end of the background information here. Folks often ask me about, kind of timeline, so I put together a timeline, a really simple one, if you're interested in it at all or what's going on with patents. So the timeline starts when you have an invention that you want to talk to somebody about. If you're working for an employer who has any control over the inventions that you come up with, say you're an employee of the University of Michigan or you're an employee of IBM or most companies that are doing any kind of research and development are going to have control over things that you invent that are related to your work. You would file an invention report. That would happen here at the University of Michigan. You would file one, and I'll show you where to go get that. And typically that's going to be something on the order of days or months before any other action happens, right? So that's the negative days and months. And so the next thing that's going to happen, and I'll reiterate that this is a typical. There's a zillion different versions of this, including not even having this step. But typically, folks file a provisional application. It's called a provisional application because it's provisional. It's an application that's basically a placeholder. It says, I've invented the recipe for a cake. I'm not ready to apply for a full patent on my recipe yet. I'm just claiming the fact that I have, in fact, invented a recipe. Here's the recipe. I'll get around to filing a more full application later. When that application goes in, you're securing the priority date. If anybody else comes up with a recipe for a cake that looks like your recipe for a cake and they did it after that date, you would have priority over them. Your patent would be dominant over theirs. That's why you try to move things in as a provisional application, is you want that priority date. Next thing that comes after that, in 12 months or less, is going to be the utility application. Typically it's 12 months because you use those 12 months to figure out what else you need to know about your cake recipe as you're busy modeling it all out or testing it, and I think cake testing probably is good, tasty thing to do. But you have to do it within 12 months. And you're going to file what's called a utility application. That is an application that describes something that's actually useful, right? You've put your recipe in. This is your full official patent application. 18 months from the earliest filing, and if we did a provisional and then we waited and did the 12 months later on the utility, that's going to be 18 months from this. If we filed just a utility application straight up and didn't even bother with this at all, it would be 18 months from when we filed that. 18 months from when we file it, the whole world gets to read it. Remember the Coca-Cola example, right? There's a reason not to do that. It's because you are required to publish. The patent office publishes this. Now, by the time they publish it, you may have already changed your application, and maybe there are a lot of changes that happen after the fact that the rest of the world doesn't get to see. But the idea behind a patent, the reason why governments provide patents, is it says, you know what, we want technological innovation to get into the world. And so we're going to encourage you to take things out of trade secret and get them into sharing it with other human beings. In turn, allow that to happen. We'll give you a monopoly for a period of time, but in exchange for that monopoly, you have to publish. You have to tell everybody what it is you're doing, right? So then we get the rest of things. So what's the rest of things? We've got our application in. It might take sort of a common time frame is maybe 2 to 4 years to get the patent examined and then issued, right? And then after it's issued, it's enforceable, hopefully, if you've done a patent that's valid. And it's enforceable for a period which is about 21 years. It's actually 20 years after the utility filing. So if we started counting up here, that's 21 years. Right? And at that point, the patent expires, and anyone can follow your recipe without having to pay you anything. Unless, of course, you have some other patents which overlap with it, and that's really cool, or you have a drug and you've gotten some extra special protections from the government that have nothing to do with your patent, really, but have to do with trying to encourage folks to have more drugs. Okay, so this is the end of the background session. Now I'm going to tell you things that I think you really, 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 really need to know. Okay? This is the secret, most important stuff. If you have any questions about the background, don't hesitate. Okay. So remember when we talked about risks? I gave a whole lecture on risks, and I said one of the risks that you need to deal with is your intellectual property, your IP risks. We're going to talk about 2 of the biggest IP risks there are, and major mistakes that people make, and complete collapse of commercial opportunity for inventors if we don't get these right. Okay. So risk number 1, thing number 1 that we're going to talk about is if anyone ever publicly disclosed the idea that you want a patent, then it can't be patented. Right? So I've already told you that this is a problem. In the U.S., you have a grace period. However, if somebody else comes up with the idea, you no longer have the grace period. It doesn't belong to anybody. All right. This is prior art. So prior art is problem number 1. Let's talk a little bit about prior art. So an example of prior art, and the ABC example is what we're going to use a lot, and it's not uncommon in the space. So let's imagine that the alphabet are things, right? So wheels, rubber, spokes, things like that. And the whole world knows about thing A and thing B and thing C. And so you couldn't patent a wheel because someone's already invented it and everybody talked about it and people have known about it for, I don't know, thousands of years. So that's prior art. But you figure out how to combine things in a way that they have never been combined before, and you show that that's actually useful and not obvious. And you could say that A plus B plus C is something that's patentable, right? So you would be getting by the prior art by combining things which people may be familiar with in a way that they're not familiar with. And again, you'd have to argue to the patent office that they wouldn't be obvious to someone skilled in the art. But let's assume for the rest of this description that someone's already gotten a patent on ABC, and they have claims which say a thing comprised of A plus B plus C. So ABC is patented. What does that mean for the rest of the lecture? Okay. So you can beat the novelty issue, right? So if someone had disclosed ABC, maybe the patent's even expired on ABC, but ABC has been discussed. So how do you get a patent on something that involves A, B, and C? So that you have a novelty issue. You may be able to get by that by adding something, and that makes an invention over top of the prior art. So in this case, we would add D, right? A, B, C, D. And if that combination is novel and useful and not obvious, then you might be able to get a patent on it. Okay? So you would be advancing the world. There's a challenge with this, however, and that is D, the addition of D to ABC has to make ABC much better in a way that's going to be commercially useful to you. Otherwise, there's really not any point in it. And what I mean by that is if ABCD is just as useful and as much fun to have as ABC or ABCE or ABCF or any other variation we can think about, it doesn't really serve as a barrier to entry, right? So if you think, wow, there's an awesome opportunity in the world if only we could append something to ABC, that would be awesome. And you say, I'm going to figure out how to get a patent because I'm going to add this to ABC and it's going to make it so much better. So ABC plus something is much better. Everyone's going to want to buy it. They're all going to want to have it. I don't have a patent on ABCE or ABCF or ABC anything else. If everybody else can go out and make ABC plus something and it just isn't ABCD, and those things are as good as what you came up with, you haven't prevented anybody from entering your market. You've come up with a great idea, and everybody else is going to make money off of it because you can't stop them, right? So that's the problem with beating prior art with novelty. It is possible to do, but you need to think about it. Okay. So patentability is only half of the equation. Does anybody want to take a guess what the other half of the equation is? Risk number 2. What do you think risk number 2 is? I actually gave it in a prior lecture, but it's all right. Nobody? All right. So risk number 2. If any part of your new idea has been previously patented, then the new idea might be blocked from commercial use. And I'm going to explain how that's a problem. What we're talking about here is 3 letters, FTO. They stand for freedom to operate. You guys familiar with freedom to operate? Anybody had to worry about overcoming freedom to operate before? Anybody? Show of hands? No? If you want to go forward, you're going to have to worry about this. Okay. So one of the critical things to understand about patents is that they protect, but they do not enable. right? So a patent blocks other people from using your invention. That's why we have it. Remember? We wanted a barrier to entry. We wanted to block other people. Okay? It excludes, technically, it excludes people from making, using, selling, or importing the claimed invention. And a patent can also be thought of as the right to sue anyone who practices your invention without your permission. I have a recipe for a cake. No one else is allowed to do my recipe without permission from me. A patent is not the right to practice the invention. And what I mean by that is, if you have a patent on your recipe, it doesn't mean that you're allowed to use your recipe. And I'll show you why that's a problem. And the most common thing that probably comes to mind is penguins. That's a joke. It probably never comes to mind. So we're going to talk about penguins. And the reason we're going to talk about penguins is they're very clever little fellows, and they have lots of inventions. So we're going to talk about how their inventions are affected by freedom to operate. Okay, so take your penguin on a beach, right? Comes up on the beach, got something to do. Trust me, this has to do with patents. So the first thing that our inventive penguin is going to do is select a location to build a nest. Right? So they wander up on the beach, they took a look around, they say, that's the best spot. I'm going to get there before anybody else can get there because that's the best spot to build a nest. So that's their invention, is identifying this location. At least that's the invention in this metaphor. So the next thing they're going to do is they're going to build a nest. That's supposed to represent a circle of rocks and twigs and other things that they use to build their little nests. So they build their nest and they say, this is my nest, nobody else come here. Right? So that's their filing their patent. And then they're going to commute back and forth from the ocean to their nest, and that's how they're using their invention. Right? So everything's good so far. All right. The circle of their nest, where they put their little stones and they say, this is mine, stay away from it, can be thought of as the space that's protected by their patents. So going back to the mining claim concept, this is my space, only I'm allowed to dig for gold here. They're like, only I'm allowed to have a nest here. This is my space. I'm claiming it. The space around that, so everything else on the beach that's around them, is open space. And all inventors, penguins, are free to operate in that space. They can commute back and forth all they want. Because there's no patent claims on the rest of the beach. So this is where we get our freedom to operate concept. And it's a term that we use to discuss whether or not a patent would infringe on the claims of another patent. I'll talk about infringement in a second. But it's a term that we use because this is what beaches end up looking like pretty quickly after the penguins show up. Right? They all start inventing. And they claim their space. And here you can see they're loudly proclaiming their space, doing their investor pitches. And as you can see, the beach is becoming less free. There's not as much freedom to operate around on the beach. And that's the problem we have. Okay, so our penguin comes back to the beach and everybody else has set up their nests. And that's okay. The penguin can figure out how to get to his nest. So he still has the freedom to operate his invention because he can get there. Right? Infringement is making, using, or selling, or importing something that's claimed by a patent without the permission or right of the patent owner. Okay? Actions can infringe somebody else's patent even if you have a patent on this space. Okay? So I can have a patent to a recipe for a cake, and I'm not allowed to use it. Or if I use it, somebody could sue me because I said combine eggs, flour, sugar, blah, 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 and somebody else said combine eggs and flour, and now I'm doing what they said they were doing, only I'm doing it in my recipe, and they're going to sue me. So I'm going to give more detail on that in a second here. So the problem is the owner of the patent may seek to sue the practitioner for infringement, stop commercial use, and pay damages, which in the penguin world means a peck with a beak that's sharp, painful. Penguins do draw blood. So All right. So the example we have, let's go back to ABC because it's a little clearer than cake recipes. So if we go back to the concept of ABC, and it hasn't just been disclosed, but it's actually patented. Somebody has a claim of a thing that comprises of A plus B plus C. And we figure out how to make ABCD. And ABCD is way better than ABC. And we're going to make it and we're going to sell it. The problem is whoever owns the patent for ABC is going to be able to sue us and stop us from going forward. Right? So we have a problem with freedom to operate. So performing the actions claimed in my recipe for ABCD will infringe upon the claims of a patent which claims ABC. Even though I invented D, and I invented the way to attach D to ABC, and ABCD is much better than ABC, it doesn't matter. I'm still practicing ABC in order to get to ABCD. So we would say that the patent for ABC has freedom to operate, and the patent for ABCD does not have freedom to operate and is blocked. The same would be true for ABCE and ABCF. The problem with blocking is we end up like this guy right here who's trying to get back to his nest and he can't get there because everybody has patented all around him and he can't figure out how to go back and forth from his nest. So even though he has a really cool nest in the best part of the beach, he can't get there because somebody else has blocked him. All right. So this is this slide I've never shown to anybody before, but I talk about this problem all the time. So innovators have, they may have a sense of what's going on here with this idea of freedom to operate, but they tend to, it's common for folks to put that back into novelty, right? So they'll get focused on this idea of patentability and focused on the idea of novelty. And somebody will say, well, there's already a patent for ABC. And they'll say, but ABCD is different than ABC, right? It is novel. When you say different, generally you're talking about novelty, right? But that actually doesn't solve this problem. That solves the first problem. It doesn't solve risk number 2, okay? So inventors will say, okay, but I have also ABCE and ABC to the D and ABC double D and ABCEDD and F and all these other things we're going to put in here. Those are all ways of making ABC novel, but they're not ways of getting around the problem of freedom to operate. And in our metaphor, we would be talking about one can't create freedom to operate by making novelty greater or making our nest bigger, right? Can't do that. So let me show you what we're talking about here. We start out, it's good. We're able to get back and forth from our nest to our claimed area. So we're keeping all the penguins out of that space, but we're able to get back and forth to the ocean. That's terrific. Everybody keeps inventing. They file more patents. They file more claims. So do we. That's great. Our nests get bigger. Still not a problem. Penguins can still get there. He might have to change his route. Penguins tend to meander around anyways. That's not a big deal. Still able to get to the nest. The problem is eventually it starts looking like this. Right? So if a space has been around long enough, if a commercial concept, if a product idea has been around long enough, the beach will look like this. Okay? And the problem here is there's no way for the penguin to operate without stepping on somebody else's nest. And if they step on somebody else's nest, they get pecked. Now, it's true, actually, all of these penguins, they can't get anywhere either. That's a problem for all the penguins, right? The patent office doesn't care whether or not you can get back and forth to the ocean. All they care about is whether this space has never been invented before, is novel, useful, and non-obvious. That's all the patent office cares about. They'll keep handing out patents irregardless of whether anyone can actually use those patents. That's not their job. Patents is a protection. It's not a license to use, right? So this patent, the penguin here has correctly identified the best space on the beach, and they have gotten a patent on it, but they just can't do anything with it. And no matter how much novelty they add to their nest, right, and they make this bigger and bigger and bigger, it doesn't solve the problem that these other nests are there blocking their way. Right? So we can't solve freedom to operate by adding novelty. But inventors want to do that. That's the way, generally they're adding novelty to the world. Their solution to most problems is to add more novelty. It doesn't work for this particular problem. And this problem is a big deal. Okay? Now, if you were, I will say, if you were somehow or another able to make your nest as big as the beach so that your nest went all the way to the edge of the water before anybody else could get their nests in place, you'd be okay. Right? So what you should do is do a lot of inventing before you tell anybody about it, and that way nobody knows about the beach until you've got the beach totally covered. That's a trick. I'll talk a little about that trick in a minute. It's not that easy. Okay. Don't despair, penguins. There are ways around this. One of the ways is to go to another beach. You can achieve freedom to operate if you avoid other people's claims entirely. Okay? You just don't try to cross that portion of the beach. So XYZ does not infringe ABC. And even though ABCD infringes ABC, XYZD does not infringe ABC. It's quite simple. You read the claims, and if the claims say ABC and you don't do ABC, then you don't infringe them. You have to perform a claim in its entirety to infringe it. Okay? So if someone says, I have a patent on ABC, and you're doing A plus B, but you don't have any C's in there at all, you're not infringing their claim. Because their claim is you do all of this. And when you write that in the sentence, you have to do all of that in order to be infringing. It's also true that if you substitute in ABD and go straight to D, or you stick an X in the middle of it, none of that stuff infringes ABC. And your invention may be a way around that. So here's where we're doing things that are novel. We're not just adding novelty to something that exists, we're reinventing that thing. And often if we reinvent, we can get around the problem of freedom to operate. It's another example here, penguins and bicycles, well known. So if I come up with some claims for what we might put on a bicycle, a method of braking a wheel by applying a friction pad, a brake for a bicycle comprising opposing discs attached to the front wheel and bearing on each other when activated, a method of remote control of mechanical functions on a bicycle using levers and cables. All of you can buy bikes that have all these. A method of controlling braking force using handlebar-mounted actuators. I don't know why penguins would want that because they can't reach and their flippers don't really do them any good. But all of these things are on a bicycle, right? And if you had, the reason I put these up here because they're more practical, there may be something you recognize more than the nest of a penguin. If you had the patent on this and someone else has the patent on that, depending on what you want to do, you may be infringing, one or the other may be infringing, right? So if someone had this before I had that, and I wanted to start making bicycles, I'd be infringing their patent. Because I have a friction pad, and this would have a friction pad. Conversely, if this is around at first, and then I figure out a way to do this, I can say, but this is on a bicycle. It's not on anything, it's only on a bicycle. Well, that doesn't do me any good because this doesn't say anything about whether it's a bicycle or whether it's a front caliper brake or whether it's a front disc brake or anything else. It just says if you have a brake with friction pads, any form of a brake with friction pads is going to be a problem, right? This one here, remote control of function using levers and cables, right? And then handlebar mounted actuators. It may be, if I can come up with a way to make an actuator that's not a lever and doesn't involve cables, then I'm free of freedom to operate from this. But if I want to do the conventional put a lever on my handlebar and have it operated by a cable, I'm stuck because of this one. These are the kinds of nests on the beach that we have to deal with. And we have to deal with them all the time. This is just, it happens all the time. And you'll find claims that look something like this, where they're like, well, it doesn't exactly describe what I do. Yeah, but when you actually try to make the product, your product is going to have levers and cables, and then it will be infringing on this. So you have to read what everybody else is doing and figure out if there's a way to do it that doesn't involve exactly what they say. If you can figure out a way to do it with levers but not cables, you can figure out how to do it with cables but not levers, you're not infringing on that patent claim. So how do we mitigate the risks from risk number 1 and risk number 2, prior art and FTO? Okay? We have to search. Okay? This is the number 1 instruction that would give to anybody who wants to innovate. You have to search for patentability. So prior art could be anywhere. You have to look everywhere. Google is really helpful for that. Right? So inventors are typically well positioned to find prior art. So if you're in the inventing bicycle parts, you probably know all about the bicycle part literature. You know who might have thought about bicycle parts before. You've been to bicycle part meetings. You know what abstracts are in the bicycle part meeting books. Those abstracts are prior art. And if you're an employee here at the University of Michigan, you can go to OTT and you can say, here's my invention report. I have this great idea. And they'll help you think through what prior art you need to worry about. And if you find something that you're concerned might be prior art, they can help provide guidance on what how to deal with that. You also have to search for your freedom to operate. You have to know what other people are claiming. So it is essential that inventors look for, consider, and seek counsel about competing patents or applications. You have to search. And the problem is, as beaches get crowded, there's a lot of searching to do. But you have to search, otherwise you end up like this guy who can't find a way to get back to his nest. Okay? When you're searching for prior art, you're searching everything. Anything anybody's ever said or written, doesn't matter whether it's in a patent or in a book or in a newspaper article, doesn't matter, right? And you can even say, well, there's this in the newspaper article and that in the book, and they didn't ever think about it, and they didn't actually say that if you put A, B together plus C together and that makes this thing, and then the patent examiner will say, yeah, but if I read the book and the newspaper, I'd figure out that it was kind of obvious to put them together, so anybody could have done that, and then they'll reject it. So you need to know all of that stuff and then be able to argue back. For freedom to operate, you need to search the patent claims in patents or patent applications that predate your priority date. Okay? So it is a smaller universe you have to work on, but it's a universe that's really lethal. You have to spend a lot of time looking at it. I do recommend people say, well, how am I going to do this? I say Google. So if you go to Google Patents, you can start looking for penguins. And there's a lot to learn about how to search for patents. Google has a really nice thing where they teach you how to do that. They even have this feature. If we go back here, you'll see this bit right here, include non-patent literature. That's how you search for prior art. Right? So this is really a freedom to operate search unless you click that box, and then it becomes a prior art search. Okay? That's why it says right here, search for prior art all in one place. Okay. Some folks confuse freedom to operate with a freedom to operate opinion. Right? And so, well, I need to worry about freedom to operate, so I'm going to get an opinion. And somebody will say, no, you don't need an opinion right now. No, it's expensive. You do that later. We're talking about different things. So freedom to operate is a concept. It's a state of being. Hopefully you have it and you're enjoying it. And if you don't have it, it's an aspiration. It's different from a freedom to operate opinion or a freedom to operate letter. That's a legal document prepared by an attorney. It's expensive. It is useful, but it's not always necessary. It's typically something you do a little later down the line. Once you've convinced yourself that you have freedom to operate and you ask an attorney to codify that with a letter saying, absolutely, our opinion, you do have freedom to operate. That way, when you get sued for infringing somebody else's patent, you'd say, no, our attorney said we weren't infringing. So even if the court finds that we were in fact infringing, we are operating under good faith that we were not infringing. And so you cannot charge us with treble damages, that is 3 times the damage. So that's why you get a freedom to operate opinion. It might also be helpful in convincing investors that you in fact have freedom to operate. But you really need is freedom to operate. You don't really need the letter, you need the state of being. I believe that innovators should always be aware of the freedom to operate concept, and they need to be looking for freedom to operate. It's never too early for you as an innovator to be looking for freedom to operate. It's usually in the early stages it's going to be too early for you to be worried about talking to an attorney about it. It'd be too early for, say, even the tech transfer office to be worried about paying for looking for freedom to operate. But you can use Google Patents. I recommend that you do. So bottom line here is patents block others. So patents are a good thing to have because they prevent other people from getting into your space. Right? Even if your patentability is weak, ABCD, everybody knows about ABC, anybody can make ABCE or ABCF, so there's really weak, right? But I can figure out some other way. I can get a patent on something else that provides my barrier to interest. So you can get around weak patentability often if you can figure out some feature that's important that you can, just some little piece that will control the space. If you can get even a very small nest right where everybody wants to walk, you control the walkway. Freedom to operate blocks you, and it's a really bad thing if you don't have, or if you have a freedom to operate interference problem. So if your FTO is blocked, if you don't have freedom to operate, you are stuck. Okay? Stuck completely. And as I said in my previous lecture, freedom to operate is a fast-acting killer. Okay? If you're in a startup business and you have a great idea and you're moving along and then you keep searching and then you find this patent, I have been there, 3 in the morning, you get a call, crap, look what I just found. Our patents aren't any good because this other patent exists. We're stuck. That actually can kill a project in its entirety right there. So worry about freedom to operate. There are ways around it, but if you don't know about it, you can't get around it, right? So I'll just finish here. So what if you are an intrepid penguin and you have an invention? What do you do next? This is the bit about we wanted to cover the whole beach with our nest. It's a great idea. It's really hard to do. So the problem is, so rights are based on first to file. They have been for many years in the United States, and they have been in Europe and most of the world ever for a long time. What first to file means is the first person who shows up with a fully functional recipe for a cake gets the patent to the cake, right? You don't get any patent rights for inventions that you document in secret and don't put into patent applications. You can't say, but I had this idea 10 years ago and I wrote it down and I had it documented by an attorney and I put it in a safe and so it's my idea. That used to work in the United States. It doesn't work anymore. Okay? So you have to get around to filing things. So you can find the best beach and figure out the best spot on the beach, but you can't not tell anybody there's a beach there. You have to tell them there's a beach and this is my spot on the beach. Also, if you publicly disclose any part of your invention, you're in trouble. So if you put in a paper and you say AB is really cool, and then you want to patent ABC, you can't patent AB anymore because you have prior arted yourself. Your own words have created prior art. And so the most you could get out of that is the combination of AB plus C, which is a problem because if AB is actually pretty good, everybody else can use it now for free. So you have to disclose things. You should disclose them to your attorney. You shouldn't disclose them to the world until you have to. The problem is when you eventually get around to telling people, so this happens all the time. We have people here at the university. They have done some research. It's terrific research. They say, hey, I'm putting together a paper. We're going to publish this awesome research in this awesome journal, and we want to make sure we're doing the right thing by getting the publication in. but we also want to make sure we're getting our patent. So we get the patent application, we put the patent application in, then the paper comes out. And as soon as the paper comes out, if it's really interesting things, all the competition reads the paper and they immediately start going and making new patents on your idea. Immediately. Okay? So you can have a paper that talks about ABC, and you can have a patent application that was filed in advance for ABC, and the competition will be creating nests all over the beach. Right? And by the time you ever get around to actually doing anything on the beach, all the competition has taken up all the spots. Nobody can get anywhere. You have to license rights is what comes out. The problem is you lose your total control of the space. In a preferred world, you would have an invention so big that it would cover the beach, and you would do all that before you told anybody about it, but then you would file a patent so that nobody else could get to it. Nobody else could have that idea. It's a challenge to put together the secrecy, the publishing, the timing, putting all that together is not easy. Okay, so first step for inventors at the University of Michigan, submit your application. This is the website for the Tech Transfer Office. This is the invention report part. And that's the end of this lecture. So, anyone have any questions about intellectual property? Yes?
What counts as public disclosure? Like how?
Anything.
So if you were to show it to, so you have an invention and you would show it to a colleague and like, hey, this thing.
So, anyone that's not covered by a secrecy agreement. When you're working with a colleague who's an employee here at the University of Michigan, they are considered to be part of your secret family. If you talk to a colleague at Johns Hopkins, you've disclosed. Unless you had a written piece of paper with that colleague at Johns Hopkins that says, I promise not to disclose any secret information I get, a non-disclosure agreement. No. Does that answer the question? Any other questions? Yeah.
Some licensing folks talk about the first to the market strategy just due to the time length and the expense of patents.
Yeah.
I think that usually seems to be the case in software where there's a lot of open source stuff. Is that just, I assume, not at all working in life science?
So the question is about first to market as opposed to patenting. So those are basically different ways to get barrier to entry. The idea with first to market as a barrier to entry is you get there and you have so much momentum in the marketplace. You've gathered so many of the customers are now your customers. They belong to your brand. They like working with you. They don't want to shift to another company. That by the time other companies catch up with you, it's too late. Right? So everybody all the penguins have come to the beach and they're all having margaritas with you, and somebody else shows up on the beach, and even though there are no nests, the beach is covered with people having a party. It's too late. So that's the idea behind first to market. First to market is fine. It's really hard to do in the life sciences, particularly in things like diagnostics devices or drugs, because it takes such a long time to actually start the party on the beach. Right? I mean, you got to do drug development and you got to get approval and all that other stuff. So that can take years. It's not like software where we're going to race to code it and get a minimum valuable product out there as fast as possible, get the early adopters, get a lot of press, and get people starting interested in what we're doing, and therefore we'll protect the market. So that's why it doesn't happen so much in life sciences, because life science product development takes a long time. Any other questions? Yeah.
What happened to the story you mentioned? You got a call at 3 a.m.
Yeah.
What happened at the end?
We invented around it.
Yeah.
So the question is, what happened about the 3 a.m. call where, it's really kind of a cold sweat moment. So we figured out that we were not going to be able to do A, B, C, D, so we figured out how to do X, Y, Z, D.
Okay, that's one way to bypass, to get around FDA.
Yeah. Yeah. We figured out a way to do what we wanted to do, which was D, without perfectly matching the claims that were in someone else's patent. Right? Yes?
Just kind of a quick question. So in the news recently is the CRISPR-Cas9 system
Yeah.
with UC Berkeley filing first, all cells
Yeah.
with that system. And then you've got Broad Institute, which is filing later and saying, actually, we're just looking at eukaryotic cells.
Yeah.
It sounds like all cells is a large net
Yeah.
and eukaryotic is infringing on that. Do you have, I mean, I don't know details about it, but
Yeah, so the question is about the University of California versus the Broad Institute on the CRISPR-Cas9 patents. I would say that we don't actually know how that's going to turn out. We have a ruling, but there's going to be more. So the story's not over on that one. I really can't. I don't have a good explanation for why the ruling went one way. There are we occasionally get rulings that surprise us. I'm not sure that ruling was a surprise to everyone. I don't have an explanation for it. I can tell you that these are the principles that are generally applied. I will say that in patent law we have statutes, and then we have how courts have interpreted the statutes. This is typical for all law, but it's very much an issue in the patent space. We kind of have to see how somebody interpreted whether or not something was dominant over something else, and then we say, okay, those are the rules. Now we know what they are. So I would say the CRISPR case is going to tell us something about the rules.